Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Here we are again on the Bottled Business Sense show. It's Tuesday at 10 a.m. I'm Rick Moscoso, one of your co-hosts here today, and on the other side is Mr. Bill Bernard. How you doing there, Bill?
I'm doing great, Rick. Thank you. Good morning to everyone, our listeners and viewers. We're here for another show. The Bottled Business Sense show, of course, every Tuesday at 10 a.m. And obviously what we try to do here is to every week give you a little tidbit of business news, if you will, that encompasses estate planning news, employment issues, asset protection issues, and ways to essentially not only market your business but do it safely by having it protected. Business in a bottle, so to speak, and you know, that's what we're here for, to give you free information that you might be able to adapt to your specific information. And Rick and I always try to come up with some topics that are contemporary in nature and that might be practical topics that affect everybody's business on a daily basis, right, Rick? And I mean, that's really what we're here for.
Yeah, we want to keep the viewers and listeners informed with, like you said, contemporary things that are going on in the field of business as it pertains to both legal and marketing aspects of their business. And you know, we have pretty good pulse on that. Wouldn't you say, Bill?
I think we do, and we're especially dedicated. I mean, it's a beautiful day out there today, and we're in here recording our shows for the benefit of our listeners and viewers. And don't get us wrong, we're happy to do that. It's a privilege because we couldn't do what we love to do here if it wasn't for all of you guys out there willing to pay attention and pick up the ball and run with it. Today, I thought, Rick, we'd talk about something that is practical from an everyday standpoint in businesses that have employees, because arbitration is becoming more and more popular today. It's a method of allowing disputes to be resolved outside of the courtroom. And while I don't want to fool anybody and make them think that when we say we want to keep them off the courthouse steps, we also want to keep them out of the arbitrator's back room as well. But if you are presented with these issues and you have to resolve them through some sort of litigation, we want to make sure that you're also aware of what an arbitration agreement is, generally speaking, and how it adapts to an employer-employee relationship today. So that's what we're here to tackle today.
Yeah, that's great. I think it would be prudent then to start off with a couple of definitions for our audience then.
Well, arbitration is a way of resolving disputes outside of the court, as I just mentioned. And of course, it's a less formal way to do it than a courtroom. And it is not utilizing taxpayer dollars the way a courtroom would, obviously. But it all stems from, and you know, we've talked about this on the show so many times, haven't we, Rick? You know, contracts are really the foundation of everything that you do in business, from my perspective, and of course what I do in my practice. And an arbitration comes about by way of a contract. Now, there are courts where you go into court, and when you have a case in court, the court may order you to arbitration. But that type of an arbitration is court ordered and you're already in court and action's already been filed in court at the time that it goes to arbitration.
No.
So here today we're talking about private arbitration.
Why would a court order? Give me an example of why a court would order arbitration.
Well, for a number of very specific reasons. Number one, it might promote a general understanding and picture of what your case is worth, what the value of the case may be once a trained arbitrator makes a decision. And we'll get into binding and non-binding arbitration in a little bit here, but let's say the court orders it to non-binding arbitration. Okay, that's what the court is going to order, a non-binding arbitration, meaning that the arbitrator is going to make a decision, but it's not binding on you. You still get to come back to court later on and have your case put on your case and have a jury decide it. So number one, an arbitration that's court ordered will give you an opportunity to see what the value of your case may be, because an arbitrator is going to make a decision based on the very same evidence, generally speaking, that you would put on before a jury. Now, he's not a jury, but he is presumably trained in the area that will be arbitrated, and he's going to give you, hopefully, an objective opinion. Secondarily, it promotes settlement many times. Once an arbitration takes place and you get an understanding of what the value might be of your case, well, then it typically may lead to settlement, and that takes it out of the court system and therefore allows the court calendar to be less clogged than it already is.
How complex do the proceedings, or can the proceedings be? I mean, do they actually call witnesses through this process too, or how does that work?
Well, it's an interesting question. Arbitrations can be of the type where you just come in and speak to the arbitrator. I've seen arbitrations where both sides are in the room and they're just talking their case to the arbitrator and showing him documentation. I've seen arbitrations where one party will be out of the room and speak to the arbitrator. That's more leaning towards a mediation, but I have seen those. And then I've seen arbitrations where typically you put on your case just as you would in a courtroom. The rules of evidence are followed to a large extent, and the case is put on, and the arbitrator is going to be the trier of fact and the trier of the law, whereas we know in a courtroom it's the judge who's the trier of the law and the jury who's the trier of fact. So arbitration clauses are very important in a contract, and they can be very simplistic, and they can range all the way to the more complex, where it talks about who's going to get attorney's fees and whether the arbitration is going to be a final. And that leads us into a discussion basically about mandatory versus voluntary arbitration. So we're talking about mandatory arbitration versus voluntary arbitration. We spoke briefly a minute ago about the court. The court will order you to arbitration. If you're in court, that's mandatory. Voluntary is where you request the court to provide you with arbitration, or where you talk to the parties involved and you say, hey, let's go to arbitration before we file this lawsuit. Or you may be in the lawsuit and say, hey, would you opt for voluntary arbitration? So it's either mandatory or voluntary, and then of course you get into binding versus non-binding. Non-binding arbitration is where you have a chance to, after the award is given by the arbitrator, you can go back to court and have your case heard by a jury. Binding arbitration, I beg your pardon, binding arbitration is where the decision of the arbitrator is final and you don't have the option to appeal it to a court.
So are you saying then a lawsuit can already be in progress and the judge either decides or the two sides suggest or ask for an arbitration midstream? Can that happen?
Sure. Well, it wouldn't happen midstream, Rick. It would happen at the beginning of the case. For example, a lawsuit's filed. You'd go in typically for what's called a CMC, or a case management conference. At that conference, you'd speak to the judge, tell him generally what the case is about, and the judge may say to you, would you be in favor of arbitration? Or the court may say, I'm ordering you to arbitration. So the first instance would be voluntary arbitration. The second instance would be mandatory. So now that we've discussed mandatory and voluntary, I don't want to confuse that with binding versus non-binding, because principally what we want to talk about today is the type of arbitration that's contractually binding on the parties. In other words, they have a written contract that says we are going to arbitration, and that arbitration will take the place of a lawsuit. That's generally a binding arbitration. Or they have a contract that says before we go to court, you must participate in a non-binding arbitration. Give us a chance to resolve it by way of arbitration. If that doesn't work, then the lawsuit can be filed. So the type of arbitration we're talking about today between an employer and employee is principally found in contract and takes place before a lawsuit is ever filed, which is not to be confused from the prior discussion we just had, where a court can order you to arbitration or ask you if you want to go to arbitration after the lawsuit's already filed.
Now, let me ask you this. Now, I don't know if you're going to address this later on, but couldn't the process of going to arbitration, if you're already or just about to be starting court, can't that be even more expensive for the client?
Well, you know, the old story used to be, well, let's go to arbitration because it's less expensive than a court, because you've got to have to pay court reporter fees with a court. You're going to have to pay jury fees. You're going to have to pay filing fees when you file your lawsuit. You may have motions where you have to file motions, and that costs money to file motions and have various discovery disputes resolved. But the idea was to give this money to an arbitrator and just proceed and not have all these extraneous costs. But don't be fooled. An arbitrator many times can be very expensive, and he or she is going to want you to conduct discovery anyway, as you would in a court, and you may have to present him with issues concerning discovery that he's going to charge you for by way of review. So an arbitrator can be expensive. Many times it can be less expensive than an actual court trial, but there's where you have to weigh the advantages and disadvantages on the type of case you have. Is it a large, complex case that might be better suited for an arbitration or a court? And you know, when these arbitration contracts or these clauses in a contract between an employer or an employee, or between any business and another business, should there be a business dispute, when they are put in a contract, they are going to be of the type where you either accept the terms or you don't. You either sign that arbitration contract or you don't. And I should specifically say you're really just signing a contract that has an arbitration provision in it. So I think it behooves everyone in an employer-employee relationship, which is especially what we're trying to discuss here today, to understand that it's not so much a matter of cost when you come to get this job. It's a question of, do you have to sign the arbitration agreement? And secondarily, is the arbitration agreement enforceable? So we're leaving cost aside, because I come to you for a job, Rick, and you're saying, yeah, I'll give you a job, but you have to sign this agreement, meaning if there's any dispute between us, we go to arbitration. Well, now you're left with the decision, okay, do I have to sign it? And then secondly, after you sign it, you may ask the question, well, is it enforceable? Okay? Mm-hmm. So the idea of cost has already been determined by the employer when he's decided to try to resolve his disputes by arbitration versus going into the courthouse. Okay? So let's look at this and ask, generally speaking, is an arbitration agreement, is it something that is enforceable in California? Well, yes, generally speaking, they're enforceable. They're only struck down if there's some sort of fraud involved, or if there's some sort of misuse of power by the arbitrator, or if there's terms that are particular to one side and not equal for the other. For example, you may have a contract that says that that the employer can seek his attorney's fees if he's successful in the dispute, but the employee cannot. Many courts would find, presumably that would be unfair, and that if you're going to have a provision for attorney's fees, it should apply to the winning party, not just to one party over the other. Okay, so generally speaking, these agreements are enforceable as long as they're prepared in a cogent manner that's fair to both sides, and as long as there's no foul play involved, both during the preparation of the arbitration agreement and in the course of conduct that the arbitrator performs, during the time of the arbitration. Okay, so that's one thing important that we need to keep in mind. And you asked earlier, why would somebody, what would be the options of going for an arbitration agreement? Well, now we can be a little more specific, Rick, and we can say, why would an employer want to implement an arbitration agreement? We can certainly speak to that issue. But before we get into that, and before we get into some other issues involving these employer-employee arbitration agreements, let's take a quick break and speak about our sponsor today.
All right.
And our sponsor is somebody that I would highly recommend to any growing business, and even to an established business, in fact, who needs some guidance and some help and some objective thought put into their marketing consultation. Do they need various aspects of marketing that maybe they're not using? Do they want to take their company in a different direction? Do they want to get more organized? Well, I'm specifically talking about a business consultant, a business coach, and his name is Steve Smith, and he's in Lake Forest, California. And Steve is uniquely trained to be able to provide your business with the roadmap that it needs to find its way to more profitability, essentially. And you'd be surprised. This is not the kind of individual who swoops in, swoops in and says, okay, I'm waving a magic wand and now your business is going to be worth millions and millions of dollars. No, he gives you a roadmap that you have to follow, that you have to implement, and I guarantee you, take my word for it, that if you do it, your business is going to be on the rise much quicker than you might have imagined, because your work and your effort's going to be involved in making this business grow according to the things that he teaches you. So an established business can be more organized and more profitable. A young business can be pointed in the right direction, because let's face it, Rick, not everybody who goes into business has marketing experience. They may be a professional in the thing that, or the service or the product that they provide or manufacture, but that doesn't necessarily mean that they attended the greatest marketing college in the world and have a marketing degree. That just isn't so. So Steve is the guy you want to see, and I can personally vet him and give you any recommendation you need if you want to discuss those options with me personally. And where can we get a hold of Steve Smith, Rick?
Well, we can. The audience can get a hold of Steve at his email is steve@growthsourcecoaching.com, or send him an email. You can send him an email there, or go to his website at growthsourcecoaching.com and call him directly at 949-951-9163. He's located in Lake Forest, California, but he does have clients literally all over the world. So
that's true. That's a good point, Rick. He does, and Growth Source Coaching is the name of his business, as you mentioned. And let me tell you one last thing, real quick. Steve works with large businesses and very small businesses. That's the beauty about it. And I've seen both of them in operation, because he has a program that he speaks about these issues monthly. And he's had people on who run small businesses and large businesses, and they can attest to his expertise. So please call Steve if you want to get a lowdown on how to make your business grow even more than it may already be growing.
Yep, and his contact information will be below this video if you weren't able to write it down. So give Steve a call if you need any business coaching assistance. Okay,
sounds great. Back to the show, I want to talk a little bit about employer-employee agreements in terms of, why would an employer want to opt for this? Well, generally speaking, an arbitration is going to proceed more quickly than litigation. We know that litigation is a slow process oftentimes. The courts are clogged. There are a lot of cases out there, and everybody's waiting to get their shot. I've currently had a trial continued from March to April, and I anticipate in April they may even have a hard time finding me a courtroom to try the case. So that's one reason. Second reason, again, to get a good evaluation of the case, maybe promote a settlement between the employer and the employee. Remember, an important point about arbitration too, Rick, is that it's private. Okay, it's personal. It's going to be resolved between the parties. There's not a matter of public record like there would be in court. You file something in court, somebody can go research it and find out about the lawsuit. Sometimes, not often, not every time, but sometimes they can also find out what the settlement is, or was, or the jury award was. The only way, if it's not a jury award and it resulted in a settlement subsequent to litigation, well then sometimes a settlement agreement will make it private. But nevertheless, in a trial, that's going to be a matter of public record, and it's going to be there for the world to see should somebody want to research it.
It's interesting that's that way. I don't think a lot of people know that it's generally not public record.
Right. Well, that's true. It's private, and a lot of people like that. Also,
Bill, let me ask you before you
Sure.
go on. Who is this arbitrator, and what are their qualifications, and how does the court decide who to call on?
well, that's remember now you're back to the court system, and we're out of the court system. But to answer your question, if it's in the court system, the court will oftentimes allow the parties to decide on who the arbitrator is going to be. Now that has an overlapping similarity to the private arbitration we're talking about between employer and employee. In fact, that's one of the advantages. You may want to say it's an advantage where the parties in private arbitration get to choose the arbitrator and decide who it is that they may want to have decide the case. In court, in contrast, while the judge may allow you to choose an arbitrator, he may say, okay, we've got this list, here it is, it's a short list, you got to choose one of these 2 or 3 or 4 people. And so you may be more limited than you are in a private arbitration. Not always, but sometimes you may be. So privacy and choosing the arbitrator that you want is a big issue for an employer, and it may be for an employee as well. I think one of the things that we need to keep in mind, though, Rick, is the second part of this equation, and we've talked about, well, are they enforceable in California? But secondarily, can an employee refuse to sign an arbitration agreement with an employer? Because after all, you make a job offer to me, and you want me to sign this arbitration agreement. What if I say no? I don't want to sign any arbitration agreement. I want my day in court. If I have a problem with you down the road, buddy, I want my day in court. I don't want to sign an arbitration agreement. Can you refuse? Well, certainly you can refuse, but remember, absent some implied in fact contract or absent some civil rights violation, employment in California is terminable at will. That means the employer can terminate you at any time he wants, and the employee can quit any time he wants. Barring any of the aforementioned intervening acts. And so an employer can say, hey, your job offer is contingent upon you accepting this arbitration agreement. 6 months down the road, he asks you to come sign an arbitration agreement. If he doesn't do so at the outset of the job offer, your job is contingent upon signing this arbitration agreement between us. And barring any other issues that we just spoke about, an implied in fact contract which says it can only be fired for reasonable cause, which we talked about in another show, or barring some civil rights litigation or civil rights violation or a violation of public policy that would constitute wrongful termination, barring those things, the employer can say, you don't want to sign it? I'm going to terminate your employment. So,
could there be an instance where the employee is hired, and then the employer sometime down the road issues a arbitration agreement to them. Is that typical, or does that happen?
Well, I wouldn't say it's typical necessarily, but I think, as we just said, an employer can come to you down the road and say, okay, you're 6 months into your job, I've decided to implement this this arbitration agreement, whereas if we have a dispute, we're going to have to go to arbitration, so I want you to sign it. And as I said, barring any of the aforementioned issues concerning civil rights, wrongful termination, or implied in fact contract, you would be forced to sign it, or you could terminate your employment. Sure.
So in the state of California, basically what you're saying, he can do it either at the onset of employment, or he can do it sometime down the road at any given time.
Yes, barring any other issues that might grant you a valid cause of action for termination. So if you have an implied in fact contract, you've been there a long time, and it's implied in fact that a contract between you means that you could only be fired for a reasonable cause, and he can't terminate you at will, but you're going to have to prove that. Barring any wrongful termination because of harassment in the workplace, or retaliation, or sex discrimination, or discrimination based on your ethnicity, age, medical condition, what we would call a civil rights violation, barring any of those things, he can terminate you. If those things exist, then you're going to have to prove those things were the basis of your termination, as opposed to your refusal to sign the arbitration agreement.
Okay. Is there a resource, for those the viewers or listeners or watchers out there that maybe don't happen to be in California? Is there some place they can go, some legal site they can go to and find out if an arbitration agreement is enforceable in their state?
Not that since I practice in California, I would know all of the various resources for other states, but I can bet you dollars to donuts that if you went on Google and you Googled something along the lines of validity of arbitration agreements in state of Connecticut, or whatever state you're in, you'll come up with a number of different state sites and county sites that would give you that information. So that's what I would advise them to do. In California, you can do the same thing, or you can go to the EEOC website, which is the Equal Employment Opportunity Commission, or the California Fair Employment and Housing website, and you can ascertain what your rights would be there. So yes, there are sites out there available, but as to the other states, Rick, I wouldn't be cognizant of those unless I Google them myself.
Okay. So in California, like you said, it is enforceable in California, and declining it could definitely jeopardize your job. But
it could, yes, under certain circumstances. Yep.
Okay. So what about the instance where you have some hotshot guy out there that this company really wants, and he decides, I'm not going to sign the agreement, but the employer really wants him. What kind of options does he have then?
Well, that's a great point, and that's where some sort of a negotiation would take place. Look, if you're an employer and this guy is going to be really valuable to you, this guy or gal, and you really want her, you really want him to come on board, well, then you may decide, okay, I'm not going to have you sign this agreement, or maybe modify it to say it's going to be something along these lines. Let's make it a non-binding arbitration. Let's make it an arbitration where we go and find out if we can settle this thing, and then if not, we go to court, and then you can have your day in court. So it's not going to be binding upon you. In fact, in many attorney-client retainer agreements, attorneys will put arbitration clauses in there in order to be able to get an assessment of what's going to happen, and then allow the client to go to court if necessary. Many attorneys will try to put a binding arbitration clause in their retainer agreements. What's interesting with lawyers is you have a requirement in the county I practice in, Orange County, and in most counties you have a requirement where you have to go to the county bar association to have them determine a dispute over fees. So if a client says, you're charging me too much, or I already paid you, I don't owe you this amount of money anymore, then you would have to go have that resolved by the the bar association before it could go to court. They have direct input on say with regard to fee disputes, and that should be put in a retainer agreement, by the way, if and most lawyers understand that. But you're right, Rick, right on when you said that that an employer might have an opportunity to tweak this agreement if there's an employee who really wants to come on board. But there's also a slight drawback for an employer, and that is an employer must pay all of the attorney's fees in employment cases in a lot of instances. Where you file an action against an employer, he may be, pursuant to statute, he may have to pay attorney's fees, and an arbitration agreement would allow arbitration fees that may normally, fees that may normally be in the tens of thousands of dollars to be recompensed if he's the successful party pursuant to an arbitration agreement, which ends up resolving a dispute between the employer and the employee. So that's important. We talked a little bit about refusing to sign the agreement. We talked a little bit about the enforceability, and we talked about the negotiation tool. But remember, there's one last important point that I want to bring up with regard to these agreements, Rick. If you sign an arbitration agreement with your employer and he discriminates against you, remember that there are agencies like the Equal Employment Opportunity Commission, the Department of Fair Employment and Housing in California, the first being a federal agency, the second being a state agency here in California, that can do an investigation, and the EEOC, for example, can sue on your behalf. They can decide after an investigation, once you file a claim, that there was discrimination and that therefore you're going to have a lawsuit brought on your behalf by them. Now, let's say there is discrimination. Is that arbitration agreement going to be binding upon you? Well, typically there would be an argument that it would be, but most often, well, I shouldn't say most often, but sometimes it's put in the arbitration agreement that barring a claim of discrimination, the arbitration agreement would cover all other types of actions. So the question that we talked a little bit about before, where barring some sort of implied in fact contract or barring some sort of discrimination, I want to make it clear. If you sign an arbitration agreement, that arbitration agreement is binding whether you have any sort of a claim for termination, whether it's implied in fact contract, whether it's retaliation, whether it's a civil rights violation. It would cover that unless the arbitration agreement specifically excludes those types of claims, which of course most employers would not want it to exclude. But that does not mean the EEOC can't bring that action on your behalf, even if those claims are included in your arbitration agreement. And also, it probably is prudent to mention that if you have a claim of discrimination, for example, and you can show that this arbitration agreement was discriminatory as to your ethnicity or your race or your gender, then you might be able to bring a claim in court that says this arbitration is void because it only was applicable to people in my gender category or my race category or my ethnic category, if you can see what I'm saying.
Mm-hmm.
So it's an important distinction to make, but remember, in any case, this federal agency, the EEOC, can in fact bring a case on your behalf if they choose to do so. So these are some typical issues that come up in arbitration agreements, and it's something that an employer may want to consider when he's building his business and hiring employees, bringing on new people to work for him. He may want to consider the negotiation tool. He may want to consider what exactly he can do to make it maybe cost him a little less money should a problem arise down the road. He may want to make sure, however, he should make sure, however, that these agreements are fair to both sides, that they include attorney fees provisions, for example, for both sides, whether no matter who's victorious. Because a court may look at an employment arbitration agreement and may say it's not valid because it's not inherently fair to the employee. So this goes back to what we discussed many times previously on the show, Rick. Employer-employee rights, you have to know what they are, and you have to be fair and be on the same page. Because after all, you want to promote the growth of the employer-employee relationship, because that creates a domino effect and naturally promotes the growth of your business. You don't want to be at odds with an employee if you can help it at all.
That's right. And if for the employers out there that are listening to the show, if you don't know what those points are, then you need to call someone like Bill, who is an expert in employment law, that can point you in the right direction to talk about these things, so you are well protected, well prepared, and should the occasion arise. So, Bill, what's the best way for our viewers to get a hold of you?
Well, they can get a hold of me. I would urge them, before they got a hold of me, to explore my website or check me out, or look at avvo.com, where I have reviews. Look at my website where I have reviews, and that would be wfblegalconsulting.com. Look on LinkedIn. Check somebody out before you retain them, unless you're referred to me by somebody who already knows me or has done business with me. And my email is bill@wfblegalconsulting.com, and my phone numbers are both 949 area code. My personal cell is 413-6535, and my business phone is 698-6222.
Excellent, excellent. And if you didn't write fast enough, the information is going to be below this video for you to take a look at. So, Bill, excellent show. I learned a lot here again from you, as always, and I hope our viewers did the same, found some great value in arbitration topic today. And
well, I appreciate that, Rick. I hope they did as well. And I'm always quick with my personal information, because I almost feel guilty giving it out at times, because I want this show to be more content oriented for our viewers and listeners. And I hate advertisements myself, but when push comes to shove, obviously you're going to have to know how you can get a hold of somebody if you want to speak to them. And again, I'm happy to give a free 30-minute consultation to our viewers. Just call me up and say you've heard our show, or listened to our show, watched our show, whatever the case may be, and I'm happy to do that.
Yep, folks, you are certainly have the ability to re-watch this show if there's some part of the discussion that you missed, along with a number of other resources that we've done in the past, both on the legal topics and marketing topics. You can always go to bottledbusinesssenseshow.com to check out the archive. If you have suggestions or questions regarding the show, you want to be a guest, feel free to send them in to us at bottledbusinesssenseshow@gmail.com. We're also on social media, on Google+, Facebook, LinkedIn, and on Twitter at @BBSenseShow. So once again, Bill, that was a great topic. I'm looking forward to the next one that you have. And
I just want to mention one thing to our listeners and viewers, Rick. We enjoyed for quite a while doing this show from our studio together, and Rick and I have gotten extremely busy recently, and that hasn't happened. We're doing our shows from two separate locations. But we're going to get back into that. We're going to do it again, and I'm going to press Rick to make sure that we use his magic once again, because I think it's a great advertisement for our show. It shows you what he can do, and I don't want to leave that unsaid. So having said that, now I want you to understand that everything that makes this show up, that makes it go or tick, is because of Rick's video and marketing magic. So with that, before we close, Rick, tell everybody where we can get a hold of you and your company, R2 Visual Studios.
Well, I appreciate the kind comments there, Bill. You can reach me at Rick at r2visualstudios.com or 949-667-1182. Or just come to our website, take a look at, see some of the things that we do at r2visualstudios.com. So looking forward to getting back together in the studio here. And don't forget, folks, it's not always just Bill and I on the show. In fact, we have a number of shows coming up where we do have some guests that we will be bringing onto the show talking about various different topics. So be on the lookout for those episodes. They'll be coming to you here soon in the near future.
That's right. That's right. We don't want you to get tired of listening to just us. We want you to have the benefit of the community here. So look forward to that. And until next time, everybody, I hope you have a prosperous, wonderful business week. Go for it, and we'll look forward to seeing you next Tuesday at 10 a.m. right here on the Bottle Business Sense Show.
All right. Have a good week, everyone.
Take care.